Hi everyone. My name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We will look today in this presentation into the so-called 20th package of sanctions against Russia, which was finally adopted by the European Union end of April. It was awaited to be published much earlier, end of December 2025, beginning of 2026, but due to the position of Hungary, was vetoed. And following the change of the governing party in Hungary, was finally adopted. And we would look into it, first of all, from the normative perspective to understand the restrictions which come from those sanctions and the relevance of them for the European operators. What are the points to note? What are the points to follow? But similar to our previous discussions, we would try to put these normative restrictions into the wider geopolitical context and generally to try to answer a question of whether these sanctions have any likelihood to have a meaningful impact on Russia and whether they are the right focus of the efforts put by the relevant European legislators, or those efforts should rather be allocated towards enforcement and better monitoring of existing packages of sanctions. More specifically, we would look into the following points: the legal composition of the package. Then we would look into the main pillars, namely the blocking sanctions element, whereby the persons and companies are added to the European blocking sanctions, which are the harshest type of sanctions, prohibiting any type of relationship with those persons, except if a specific derogation applies and an exemption is granted by the national competent authorities. And then we would look into those sectoral sanctions which affect Russian energy sector, financial sector, and miscellaneous elements will be summarized at the end of the presentation. So similar to previous sanctions packages, the 20 sanctions package was adopted by a political decision at the level of the Council, where two common foreign and security policy decisions were adopted, one with respect to the blocking sanctions, and the second one with respect to sectoral sanctions. By way of reminder, there are two key European regulations, but not the only ones, which are relevant for trying to understand what type of sanctions affect the trade between the European Union and Russia. One is a so-called blocking sanctions regulation 269, which basically imposes the harshest sanctions against Russian and non-Russian entities involved in the policies which the European Union wants to change. And there's other so-called sectoral sanctions regulations, which do not prohibit all type of restrictions, relationship, only those which are specifically mentioned there. So political decision. In terms of the decision-making process, these sanctions are introduced by first a political decision at the level of the Council, and then simultaneously with them, the amendments to these two regulations, which basically create the rights and obligations for the European operators. Looking at the blocking sanctions, there are two types of changes which came from the 20th sanctions package. So-called substantive changes, meaning the changes which changed the regulation itself, and then new persons were added to the blocking sanctions list. Substantive changes are set out in the slide. There is a insignificant amendment to the designation criteria, which currently permits to list the shadow fleet operations with respect to crude oil and petroleum products. Now mineral products come on the list. There are a couple of derogations added to the sanctions which affect the assets frozen, whereby now the exemption can be granted in the circumstances when they are necessary to support European cultural policy, continue the operation of subways in Budapest and Sofia, permit the operation of Nayara Energy, which is a large Indian-based refinery, previously or maybe also today owned by Russian companies or owners, and to permit indemnity payments from the Russian insurance company Soglasia, which was designated in the 20th sanctions package. All in all, by looking at the, for example, new derogation requests, the only question comes up is why those are necessary at the level of the EU legislative acts, meaning the consent of the governments is necessary for this type of administrative matters. And second, is it really the case that, for example, the software which is produced by Tihomирov Research Institute and which is necessary for the operation of Sofia and Budapest metro lines, as that institute was involved in the development of the automation programs for the operation of those metro lines, have to be dealt at the level of the legislator. But that's just the point to reflect on the wider adequacy of the current sanctions management within the European Union to address day-to-day matters, because certainly it's highly unlikely that prior to this derogation being granted, that program was somehow disapplied or put on hold in either Bulgaria or Hungary. Then we talk about the recovery of damages in arbitrations, which is now permitted from the frozen assets, but only to the extent those damages relate to the cost incurred in the arbitration. That's again somehow difficult to grasp, but it comes from the historical discrimination between the judgments granted by national courts and arbitration awards from the perspective of the European sanctions regulation. For some reason, in accordance with Article 5 of Regulation 269, to the extent a national European court grants a judgment, that judgment can be certified from the frozen funds in the European Union, which is somehow obvious, given that ultimately the purpose of the sanctions is not to discriminate against European operators who receive the judgment and who most likely will have very limited recourse to the assets of their Russian-related opponents outside of the European Union jurisdictions. Surprisingly, no such broad exemption existed for arbitral awards, which could be satisfied of frozen funds only to the extent they are granted before the relevant person is designated as a blocked person. So even if the arbitration commenced before such designation date, even if the arbitration is related to the contract before such designation date, which often would be the case because the arbitration or a dispute would typically relate to the breach or incompliance or termination of the contract in connection with the sanctions. This arbitration award, if granted, cannot be satisfied out of the blocked assets, even if granted in favor of a European operator. So now there is a limited exemption permitting to recover costs coming from such arbitration, but only to the extent the arbitration has been commenced by blocked persons. Again, why this type of restriction was necessary and why is it maintained at this point of time remains a mystery, I would say. Recovery of damages, which has been already introduced in connection with the Russian counterparties, in essence, disregarding the dispute resolution or arbitration clauses in their contract and preferring to commence proceedings in the Russian courts, which currently acknowledge jurisdiction for the persons affected by foreign sanctions, despite the contractual dispute resolution clauses providing for foreign courts or foreign arbitration tribunals. So to address this type of disputes commenced in Russia, which certainly were often, if not always, won by Russian claimants, the European Union permitted the parties, defendants in such disputes, recover damages. So now this damages recovery clause also covers the enforcement proceedings in third-party jurisdictions. Again, arguably, given that there are very few third-party jurisdictions which recognize the enforcement of Russian judgments, the clause is of academic rather than practical utility. So the focus of the blocking sanctions pillar is, at the end of the day, what it's supposed to be: designations themselves. Quite notable designations were made in the Russian energy sector, including Bashneft and Slavneft, which are large oil and petroleum products producing companies in Russia. And we see also the multiple designations among refineries of the largest Russian oil companies, as well as their subsidiaries operating the relevant tanker fleet. Important to note, bringing this type of designation into the context, specifically the United States, in essence, suspending the sanctions against Russian oil and petroleum products, is that the measures taken by the European Union seem to go into the opposite direction to what their G7 main counterpart is doing. Going to the Russian energy sector sanctions, which are coming from sectoral sanctions rather than blocking sanctions, which we've just discussed, a couple of technical changes have been introduced, more specifically a more restricted regime for the trade in tankers has been introduced, which applies to the European operators. By way of reminder, the European operators are currently already prohibited to sell oil tankers to Russia or for their operations in Russia, and they shall notify such sales to the national competent authorities. Now, two additional technical requirements have been added, namely to conduct due diligence and to put a no Russia sale clause into the relevant contracts. Again, given that the overall prohibition is already in place and applies to the sales made to Russia directly or indirectly, arguably these are technical rather than substantive changes in the regimes. Two new ports were added in Russia, which are used for the sales of Russian oil and petroleum products for the transaction ban. So the European Union operators will be, in general terms, prohibited to transact with those ports except for a limited number of exemptions specifically provided in the regulation. Again, one might question the timing of those designations. For example, the port of Tuapse, added now, has been largely made inoperational as a result of the attacks of the Ukrainian army, which occurred over the last couple of weeks, which in essence made any kind of supply of oil or petroleum products from that port impossible. For the first time, we see the designation of a non-Russian port in Indonesia, and the designation may be interesting to us, sanctions practitioners, as an example of the European sanctions or the logic of their application becoming extraterritorial in nature. By way of reminder, European sanctions have always been advocating the logic of their territorial application, meaning that they are binding for the European operators all over the world or for the operators within the European Union. So arguably, to the extent there is no European limb to the transaction or relationship, the European sanctions shall not apply. And that's the main difference between the European sanctions and the, for example, US sanctions, where the target is worldwide, regardless of whether US element is present as a general matter. And accordingly, to the extent the operators outside of the US jurisdiction engage in the transaction, they take the risk of being themselves subject to the US sanctions. This has not been the case so far with the European sanctions, which have been actually actively opposing this type of extraterritorial reach of the US sanctions and required that the relevant operations shall have the European nexus, meaning some type of connection either with the European jurisdiction or with the European operators, to be subject to restrictions. We don't know the particular background, certainly we don't know the particular factual background for the designation of that oil terminal in Indonesia, but it seems highly unlikely that any type of European operators or European jurisdiction was involved in the transaction with that oil terminal. It seems unlikely that there were EU, for example, insurance companies or banks which were processing the payments or providing insurance for the operations with the terminal. And certainly, it seems even less likely that there would be some, for example, operators of EU vessels providing the vessels for the sale of oil or petroleum products to the terminal, at least because we have not had about any type of investigations into those matters. all of which would certainly be a breach of the EU sanctions and, in principle, punishable by criminal, among other penalties. So it seems that it's just a trade between Russia and Indonesia, which is quite logical, which is occurring above the oil price cap. And in this sense, the designation of that oil terminal is the example of the extraterritorial application of the EU sanctions, whereby they were applied to this port, even despite absence of any connection with the European Union jurisdiction. We see a couple of technical amendments to the dealing with Russian LNG, which in any case is supposed to come to an end beginning of next year. By way of reminder, short-term contracts for exports of Russian LNG in European Union in principle are supposed not to be available since April this year. So it's quite clear that these type of technical amendments which prohibit LNG services or maintenance of LNG tankers in the European Union is just a corollary effect of the wider LNG ban, which is already in place. Russian financial sector has historically been another pillar of any EU sanctions package. This remains the case in the 20 sanctions package, where 20 additional Russian banks were designated for the transaction ban, meaning that subject to limit restrictions, no transactions are permitted with those banks. Again, placing that type of measure into the context of the Russian banking system in general, been disconnected with the European financial system since at least 2023, and the main payment channels being the subsidiaries of the European banks in Russia or third-party jurisdictions like Kyrgyzstan, Tajikistan, Kazakhstan, or Armenia, whereby in essence the payments will be processed through the banks in those countries. This may be classified as a symbolic measure. What is not symbolic is the second bullet point, where we see again for the first time the attempt to address this type of third country service providers, which in essence allow to continue connect Russian economy to the European payment system. We see new designations of such third-party banks in Kyrgyzstan and Laos. And we see that the process is not just a one-way street. There is an ongoing dialogue going with those jurisdictions. And accordingly, there were delistings, which again is a pretty rare phenomena in the European sanctions operators. It's quite often in the US that this dialogue is happening and listings are followed by delistings. In the European Union, given that the sanctions are administered basically by all member states, it's more difficult, but we see that it's happening. And for example, the banks of Tajikistan, who were previously listed on the same basis, have been delisted. Ongoing sanctions against crypto sector. Generally, there is a distrust of crypto sector, and the new prohibition to deal with any Russian crypto platforms or two additional assets are introduced. Question is how relevant these are for EU-Russian trends. My take is not relevant at all, but it is what it is. So to the extent you're exposed to those measures, that's something to take into account. Trade-related sanctions is another common pillar. I think the rule of thumb from the legal perspective is that to the extent you trade with Russia, either on exporting or importing side, you should check each and every item on your list for its ongoing compliance with the EU-Russian sanctions, because it's extremely difficult to get any kind of general logic for the introduction of those sanctions. You often may have some items, for example, on the metal products, which are permitted, and the other very similar items which are already prohibited. It seems to be a very complex and convoluted compromise of accommodating the interests of various EU member states which still need certain commodities when trading with Russia. So the rule of thumb for an operator is just to check every single item on its customs declaration with the up-to-date annex to the regulation 833. What is important for our general presentation is to put those restrictions into the overall context. 350 million of EU exports to Russia have been added to the restrictions or prohibitions, 400 million of Russian exports into the EU. Compare that with 1 very large crude carrier carrying approximately 2 million barrels of oil, which at the current price gives you 160 to 200 million per carrier. So the export restrictions, in essence, is about two very large crude carriers of Russian oil. And compare this type of restrictions with the, for example, ongoing purchase of Russian LNG, where we see on the graph, which I added here, that only Spain in March, so just in 1 month of March, purchased more than 300 million of Russian LNG. Same for France. We see Hungary and Bulgaria purchasing gas through pipelines, roughly in the same amount. And all in all, the total purchases of Russian gas in just the month of March is 1.3 billion, as it was reported by Korea. So you can see that these measures of imposing additional restrictions of trade between Russia and European Union are largely symbolic in nature, which is certainly a big burden for small businesses engaged in those areas. What is interesting to note, and again, the measure is limited for the time being, but important in terms of being the first step, is the attempt to address the parallel export measures. Parallel export is in essence the phenomena which emerged as early as 2022, when substantial elements of exports from the European Union to Russia have been prohibited in many jurisdictions, emerged as a hub for purchasing those items in the European Union and reselling them to Russia. So that became quite a lucrative business in neighboring Russian countries. And not only, for example, Turkey is also involved, but Central Asian republics have been involved widely. And it's something which is very visible and very traceable, because certainly European Union has its exports and imports balance sheet made on an annual basis. And it's very clear to everyone that there are a substantial number of countries which have changed their trade balance with the European Union in a very meaningful way since the start of the war. Having said this, for a very long period of time, little to none was done to address this type of parallel export in any way, although it was widely reported, even for some highly traceable goods like the elements of civil aircraft. For example, Russia is very dependent on civil aircraft from the European Union and the United States, which account for more than 90% of all civil aircraft in Russia. So for the first time, we see this type of measures been taken against Kyrgyz Republic, and only for two types of categories of goods, being the machinery for metals work, which is used for production of, among other, weapons, and the devices for the voice and image generations, which is reported to be used for drone operations. So we see this first measure being taken against Kyrgyzstan, which in essence means that this type of devices can no longer be exported from the European Union to Kyrgyzstan. And an additional service was added to the prohibition to provide business services for Russian state or legal persons in Russia, which is expanded to cyber security services. Finally, we summarize the other noteworthy elements of the 20 sanctions package on the slide, where the focus is shifting towards what one might think rather technical civil procedure measures, which would be better left to civil procedure rules in the relevant member states. But for some reason, the European Commission and the Council believe that they should step up their measures to assist the European operators. No claims clause has been expanded, although in a limited way, as well as anti-suit injunctions shall be now available for the European operators. Our assessment is that the effect of these type of measures will be very mild, if any, because of most of the enforcements with a view to avoid the effect of the European sanctions is certainly made by Russian operators within Russia, and with respect to the assets of European operators within Russia. And all of these measures are hardly relevant to address any of those points. We can see a measure which prohibits the Russian state funding for the EU research. Question is how relevant this funding was for EU research in the first place, as Russia generally underfunds even its national research, so to view this as a problem seems to be an overstretch. Nevertheless, to the extent any university or research institution has any program with Russia, which is co-funded, for example, that's certainly a point of concern now, given this new restriction. And we also see a broad exemption for CPC pipeline and related infrastructure. By way of reminder, that's the pipeline which is primarily exporting the crude of Kazakh origin through the ports of Russia, primarily to the European Union, is operated by an international consortium of European Union, American, but also Russian oil companies. And obviously, given the current constraints in the oil and oil products market following the war in Iran, it becomes even more critical that the supply of this commodity is available and that the damage which is periodically inflicted on this infrastructure is capable of being remedied. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next presentations.